fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time is broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. Welcome to the show. I am your gracious host, Daniel. And today is Judge Aaron Gauthier of Michigan. So let's get started with this. Make this bigger. I will be here, but I will have my mic muted. So let's get started.
This is set for, it's like an arraignment. Have you had a chance to review the charging document with your client?
I have, Your Honor.
Do you or he wish to have its allegations formally read?
Not at this time, Your Honor.
And how does he wish to plead to those charges?
Not guilty.
Your Honor, pleas of not guilty to an aggravated child sexually abusive material possession, computer crime, distributing or promoting sexually abusive activity, computer crime, and a possession of sexually abusive material. 6-count information. Is a forensic center referral requested?
No.
Estimated length of trial, including jury selection?
I think 2 days is accurate.
Okay. You available for a docket call the morning of March 10th?
Check my calendar, but I think the answer is yes. Yes, Your Honor.
We could do 11:10 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay, Mr. Slavin, we'll next see you with your attorney March 10th at 11:10 a.m. Okay? Did you have any other matters with me today?
No, Your Honor. Thank you,
Okay,
though.
you have a good day.
You too.
All right, next we'd have People v. Hassan Smith, file 25-6967FH. Also, you want to state your appearances, please?
Anthony Juliet, People.
Liz Elliott on behalf of Hassan Smith, who sits to my right.
All right, and we're here for sentencing on retail fraud first. After a delay that appears to not have met with success, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections to the information in that report?
One correction, Your Honor, the fines and costs and restitution are paid in full. Mr. Smith does have a receipt for that. Other than that, I wouldn't have any additions or corrections.
Okay. And Sheila, could you confirm that it is? Okay. All right, thank you. The advisory guidelines were 0 to 3 months. Any scoring challenges from the defense?
No, Your Honor.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Ms. Elliott, anything you want to say on behalf of your client?
Yes, Your Honor. Mr. Smith was placed on his delay on February 18th of 2025. He paid some of the fines and costs shortly thereafter. In March of 2025, he was arrested for an offense that was committed before this offense. He was placed on bond, and he was on bond for that offense until November of 2025. He served jail time until December of 2025, and then was placed on a 3-year term of probation for that crime out of Huron County. Both his bond and the current probation order out of Huron County prohibited him from leaving the state of Michigan. So his warrant in Maine, when he attempted to take care of that, he was told that he had to present himself to Maine to clear that up or hire local counsel, which he was, unable to do. So we're asking that Mr. Smith get the benefit of his delay, since he was largely precluded from being able to leave the state to take care of that warrant, and that the restitution was paid in full.
Mr. Smith, I don't buy that. I don't buy that at all. You could tell your probation agent, hey, I got this warrant I got to clear up, and it's required as part of my probation. You can get permission to leave the state. So that's baloney. Anything you want to tell me?
As she just said, I just got out on December, and it's only been 2 months, and I haven't had the money to make it out all the way to Maine. And that's it.
All right, thank you. Mr. Juliet, any recommendations from the people?
Well, I'm glad to hear that the restitution has been paid. I'm curious to know exactly when it was paid, because it wasn't paid at the time of this updated PSI. But I agree with the court that it happens all the time when somebody's on bond, and then the courts actually encourage them to clear up their warrants. So I don't think he's successfully completed this delay of sentence. I would ask the court to revoke it, sentence him on the underlying charge.
All right, thank you. Mr. Smith, would you please stand for the court sentence? You did not successfully complete the delay. I specifically ordered you to clear up a pending warrant for a theft in another state. You did not do so. I don't accept the excuse today for why you didn't do so. So that's a violation of the terms of the delay. So you're not entitled to the benefit of the reduction to a misdemeanor. You're here today for sentencing on a charge of felony shoplifting with the guidelines of 0 to 3 months. And you do have prior theft history, the outstanding case in Maine, a prior conviction in 2019. And then it looks like you had some other stuff in other counties, false pretenses. You've just, got a growing theft history. Fines and costs have been paid, but we do have to enter the judgment of sentence today. So I'll assess the fines and costs of $68 state costs, $130 crime victims assessment, DNA fee of $60, court cost $350, restitution $36, $20, $40 that were previously assessed, but will indicate that those are paid in full. And I think when you come to court on a felony case and you've got warrants somewhere else, and a judge says, I want you to take care of the warrants, and then I'll show you leniency, and you don't take care of the warrants, then you don't get the leniency. So I am going to order you serve 2 months in the Sheboygan County Jail, credit for 2 days previously served. That's within the advisory guidelines. The sentence will be served forthwith. You can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer, I'd give you one, but you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that appeal process, ask you to initial one copy, the other one's for you to fill out if you want to take an appeal. Yes, sir. Yes, sir.
With all respect, I've been literally dealing with both these cases for 2 years straight. I've been trying to pay my rent and do everything all at one time. I just got out of jail and I've been trying to pay my rent up to date, pay all my bills that I was late on because of that situation. And they took all my tax money from that case that I was gonna pay my restitution with.
Why did all that happen?
What do you mean?
Why did all that happen to you?
Because I.
Stole. Because you stole things.
Yeah, of
Right.
course, that's
Okay.
why I'm here.
All right, so it's not just happening to you.
I
These are
agree,
choices you're making
but
and then consequences you're paying. So you're gonna go with the bailiff for 2 months
can I
jail.
say something?
You did. You're
Can I
going with the
finish?
bailiff for two months,
Your Honor, what was the jail credit?
2 days. All right, do we have Mr. Eddie Spencer? Mr. Spencer, I've got the prison for Mr. Stribick, so let's, and Mr. Keough. You ready with Mr. McLeod?
Yes, Your Honor.
All right, let's call People v. Dustin McLeod, file 25-7066FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Flint County Prosecutor.
William Key on behalf of Dustin McLeod.
Okay, good afternoon. We're here for a docket call and also a continuing status conference on a violation. We haven't really seen any other violations since that time. That was back in November. At this point, any objection to dismissing that pending contempt?
No objection.
I assume you have no objection to that.
No objection.
Okay, the pending contempt will be dismissed. And Mr. Keough, how are we proceeding today?
Your Honor, I do believe we are prepared to enter into a plea at this time, and I have presented the prosecutor with a signed plea agreement and the court with an advice rights.
Okay. Mr. McLeod, would you please raise your right hand for me, sir? You swear to tell the truth, the whole truth, and nothing but the truth, okay? You can put your hand down. Mr. McLeod, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, just ask me. I'm happy to answer it. If you need more time to talk to Mr. Keough, you just let us know. We're happy to give you that time. Do you understand that?
Yes, sir.
All right. Now, I have to advise you the maximum penalty that you could face for the charge that you're pleading guilty to under this agreement. That'd be count 1, operating while intoxicated, third offense. That's a felony. It's punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to a year in jail, at least 48 hours to be served consecutively, 60 to 180 days community service, rehabilitative programs, cost of prosecution, emergency response, and vehicle immobilization. Do you understand the maximum penalty, sir?
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on bond for any other case at the time of this matter? Did you read and understand the rights listed on the advice of rights form that you signed? Do you have any questions for me or for Mr. Keough about any of those rights? Do you understand if you plead guilty, you'll give up those rights and won't have a trial?
Yes, sir.
And is that what you're choosing to do today?
Yes, sir.
If I accept your plea, you also give up any claim that that plea is caused by threats or by any promises beyond what's placed on the record today. Do you understand that? Also, when you plead guilty, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. But the types of issues you could raise are very limited, much more limited than if you were convicted after trial. Do you understand this? The plea agreement provides in exchange for your plea to that charge, the prosecutor will dismiss the habitual fourth notice. And there's also a sentence agreement for a county cap. Do you understand the terms of that plea agreement?
Yes, sir.
So, Mr. McLeod, that sentence agreement for the county cap is not binding on me. But if at the sentencing, I indicated that I wish to send you to the Department of Corrections, you'd be allowed an opportunity to withdraw your plea instead, not having received what you bargained for. Do you understand that?
Yes, I do.
There is an important exception to that rule. If you engaged in any misconduct between now and the sentencing by not showing up for court, absconding your bond, violating your bond, or committing a new crime, then at the sentencing, if I didn't follow the sentence agreement, you would have lost by your own misconduct the right to withdraw the plea. Do you understand that?
Yes, I do.
Other than the plea agreement, has anybody promised you anything in exchange for your plea?
No.
Has anybody threatened you to make you plead guilty?
No.
Is it your own free choice to do so?
Yes, it is.
Knowing all this, how do you wish to plead to the charge of operating while intoxicated, third offense? So, Mr. McLeod, back on October 18th of 2024, Were you operating a motor vehicle in Sheboygan County?
Yes.
And were you operating it on Galbraith Road and you agree that's a public highway?
Yes.
Before you operated the vehicle on that public highway, had you consumed alcoholic beverages?
Yes, I did.
And do I understand that you ended up having a single vehicle crash?
Yes.
Okay, and then law enforcement had some contact with you? Did they give you a test to determine the amount of alcohol in your body?
Yes, they did.
Do you remember the results of that test?
It was a 143.
Okay, and you agree that that's above the legal limit of 0.8? And at the time of that incident, did you have a prior conviction for operating while intoxicated out of the year 2000 in the 63-2 District Court?
Yes, sir.
And from the year 1999 in the 89th District Court?
Yes, sir.
And Mr. Keough, you satisfied with the factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Mr. Keough, are you aware of any other premises threats or inducements?
No, Your Honor.
Ms. Goodrich?
No.
And Mr. Keough, in your judgment, has the court fully complied with the requirements of MCR 6.302?
It has.
Ms. Goodrich?
Yes, Your Honor.
Mr. McLeod, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you are guilty of that offense. So I hereby accept your plea. Mr. Keough, we could schedule sentencing for March 17. Are you available by any chance that morning?
I'm actually not, Judge. I've got a conflict in Mackinac in the morning and Charlotte in the afternoon.
Okay. Let's see, I mean, this incident occurred some time ago, and we haven't had any recent bond issues. Any objection if I put it out to the tail end of April? You
No,
available?
that's fine, Judge. That'll be fine.
Okay, April 28, you available?
Yes.
Then let's do April 28 at 1:30 in the afternoon. And
One
Ms.
more
Good,
time with the time on that, Judge.
1:30.
Very good. Thank you.
And Ms. Goodrich, I assume no objection to continuing bond?
No objection.
Okay, bond will be continued. Mr. McLeod, your sentencing is going to be put out to April 28 at 1:30 in the afternoon here in the courtroom. And you have to cooperate with a pre-sentence report. So stop by the probation department and schedule an interview so that they can write a report. So I know more what's going on in your life these days, so that we can come up with a sentence that's appropriate. All right, any questions for me, sir? Okay, we'll see you then.
Thank you very much, Your Honor.
All right, thank you. Do you have anything else with me today, Mr. Keough?
I do have Mr. Walty, but he's incarcerated.
Mr. Who?
Walty.
Walden? Okay, let's bring him up here.
You're not eating onions wrong. You're just
Morning, we are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we're here for arraignment on a bench warrant in the case of People of the State of Michigan versus Marshall Harley. It's filed 26-7141FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, White County Prosecutor.
Liz Elliott on behalf of Marshall Harley, who sits at council table to my right.
Okay, and you know he has retained counsel. Has retained counsel been made aware of the proceeding today then?
Yes, Your Honor, his office actually called me. He was unavailable, so I stepped in for him.
Okay, very good. And I know this was a recent bind over, so it looks like we haven't even arraigned Mr. Harley on the underlying charge that's set for March 17th at 1 p.m. We'll leave that date and time as scheduled. But Mr. Harley, it's alleged that you're in contempt of court for violating the conditions of your bond. In that it's alleged that you were in possession of methamphetamine on September 2nd, 2025, and that you were in possession of Suboxone on September 11th, 2025. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at any such hearing to present evidence in your own defense and to cross-examine any of the evidence presented against you. If you are found to be in contempt, I could jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Mr. Harley, do you understand the rights that you have and the maximum penalties for the contempt?
I believe I do.
Okay. And Ms. Elliott, to know how he wishes to proceed?
Not guilty, Your Honor.
Okay, we'll enter a plea of not guilty as to the contempt. And we'll schedule it for a status conference on the pending contempt for the same date and time as the arraignment on March 17th at 1 p.m. Do you know, has he been, are there any charges that are filed based on these allegations?
Yes, Your Honor, and he just waived over on that, so that arraignment should be scheduled soon as well.
Okay. All right, and on the possession of meth and the Suboxone?
Yes.
Okay, because when I was looking at the bind over packet, it looked like he had prescriptions for Suboxone around the same time period. Okay, and bond has been set in the methamphetamine case. Is he posted in that case?
Yes.
Okay. All right. Any thoughts as to release on this contempt matter, Ms. Goodrich?
Your Honor, because of the timeline, this was in September of 2025, and he's under bond under the new case that just got waived over. I guess it would make sense to issue a bond for him to be released on this and continue monitoring the bond line and have them all scheduled together.
Okay. Any thoughts on that, Ms. Elliott?
Well, Your Honor, he lost his housing as a result of a fire in his apartment building. He's in the middle of moving to a new apartment right now. Aside from these allegations, he's not had any trouble on bond, so we'd be asking for him to have a PR bond and be released so he can continue.
Okay, he had posted, it looks like a $5,000, 10%. What I'll do is I'm going to reinstate that bond. But then I guess, and I don't know what conditions he may have in the methamphetamine case, but just the only case that's in front of me as I reviewed this is that he's pulled over last summer for a car that he bought, but hadn't yet switched over or insured. And there's a single Schedule 4 pill in his pocket. And then he gives the officers a bottle that he got from a doctor with 7 more pills in it. And they can't track down a prescription for it, but that's not always obtained. Doctors sometimes give directly without like a prescription through a pharmacy. So I don't even know whether this case, I know there was a waiver of the prelim. I'm really concerned about whether we're making a mountain out of a molehill here. And I guess I want to hear from both parties about whether on this case, he should be subjected to drug testing as he has been for 6 months for a pill in his pocket. Ms. Goodrich.
Your Honor, yeah, with the pending charges being controlled substance related, I would ask that he continue to be monitored, especially in light of the court's knowledge that methamphetamine was found on him at a later date, that there's a substance abuse issue here that needs to be monitored for public safety reasons.
All right, Ms. Elliott.
Well, I think that there's allegations that there's a substance abuse issue. I don't think those have been proven. I think that Mr. Harley was very forthright when he was pulled over by police. He's pulled over for a plate violation, and all of a sudden they're searching his pockets. Doesn't make a lot of sense to me. And then he willingly gives over this controlled substance, which led to further investigation, which led to the new charges. I think there's some question whether or not any of the drugs were even Mr. Harley's. And so I think any kind of drug testing at this point would be inappropriate.
Okay, well, the only case in front of me today is this case for possession of modafinil, a Schedule 4 substance. So in this case, I'm going to reinstate his bond, but I'm going to amend it to just a standard bond. No special conditions in this case. So the only bond conditions in this case, Mr. Harley, are that you not break the law and that you show up for court and you don't leave the state without permission. That's it. Okay. Now, I don't know what conditions you have in the other case. You have to comply with those unless and until there's an appropriate motion in front of me and maybe grounds to amend that. But in this case, we're going to reinstate the bond and get you out today, standard conditions. Okay. And we'll see you on March 17th at 1 p.m. with your lawyer. Okay. Thank you. All right, you have a good day, sir.
Hey, it's Ashley with 4 Pages.
And we're here for a resentencing on remand from the Michigan Court of Appeals in the case of People versus Marty Mitchell. It's filed 22-6430. Counsel, you want to state your appearances for the record, beginning with People?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, Your Honor. Melissa Krauskopf on behalf of Mr. Mitchell. He's present here, seated to my right.
The advisory guidelines have been scored at 12 to 24 months. Ms. Krauskopf, any scoring challenges from the defense?
No, Your Honor, I believe 12 to 24 months is accurate.
So People did file an objection to OB-19 being scored at 10 points, arguing that it should be at 15 points. Ms. Goodrich, are you continuing that objection today?
Yes, Your Honor. Your Honor, due to the amount of force that the defendant used that day, he had driven off beyond the officer's commands. And then, so they had to pull him over again. And then he refused to get out of the vehicle, rolled down the windows. They had to break through a window and then pull him away from the steering wheel. He began kicking the officers with his legs. Therefore, we believe that OB-19 is properly scored at 15 rather than 10 points.
That variable, OB-19 was scored at 10 points on the original sentence in this case. When asked if there were any additions, deletions, or corrections to the guidelines of the original sentencing, the People said no, so there was no objection made at the original sentence. Following the appeal in this case, the People did file a confession of error. The COA rejected it because we didn't quite agree on the remedy, although we agreed that there was an error. I appreciate that a resentencing opens things back up, but I will, I guess, just put on the record that I don't love the idea of that variable being scored now when the People had an opportunity to correct it previously. It feels a little punitive.
A remand for resentencing does reopen all issues for resentencing, and I've seen sometimes where then the defense has objections that they didn't have previously. As long as, I guess, if it had been presented and argued in the Court of Appeals and there was an adjudication on the issue, it of course would be law of the case, and we wouldn't be able to reopen it even if they're, like if they hold that something was improperly scored and they send it back for resentencing, we can't just, that scoring is locked in by the Court of Appeals decision. Here, the Court of Appeals remand was that I failed to, and upon review of the sentencing transcript, they're absolutely right. I failed to articulate any reasons at all for the extent of the departure. So a remand was certainly appropriate. And here, the evidence does show that Mr. Mitchell did use force and the threat of force in his interference with the officer's obligations that day, including actually forcibly kicking them. So based upon that, I would score OB-19 at 15 points, from 12 to 24 to 14 to 29. Any objection to my arithmetic or range calculations from the defense on that?
No, Your Honor, I'll just, for Mr. Mitchell's benefit, I'll just note my objection to the court scoring OB-19, but I think the court has done the math correctly based on the way the court's going to score it.
Okay, thank you. That issue is preserved. Ms. Krauskopf, anything you want to say on behalf of your client?
Your Honor, the court can take post-conviction behavior into account that is People versus Fields. And so I will note that at least from the update that we have here, he's been doing well in prison. You know, one minor misconduct for out of place is really certainly very far from the worst thing that I have seen. The report reflects that he's quiet, he's not causing anybody any problems, he's completed a program. He also informs me that he's being treated for glaucoma and severe migraines while at the prison. He was working in the kitchen, but has had to stop due to the health issues that he has been suffering. He also suffers from severe progressive degenerative disc disease, so he does have a host of health problems, but otherwise it appears that since he has been sentenced, that he has been keeping his nose clean, so to speak, in prison and doing the best he can to avail himself of programming there. I would just ask that the court consider all of that and sentence him within the appropriately scored guidelines.
All right, thank you. Mr. Mitchell, it is not required that you would make a statement here today, and if you elect not to, I don't hold that against you in any way. You also are allowed to make any statement you wish to me today. Is there anything you wish to say, sir?
Respectfully, and I understand that there was a narrative, but there's also a police report. I got out of the vehicle on my own. There was no broken windows. Nobody broke my windows. I never kicked any officers in my truck. I got out, the dog grabbed a hold of my ankle, and it was noted in the medical report that there was 4 puncture marks on my ankle. I fell back. I grabbed a hold of the steering wheel to keep from falling, and the next thing I knew, 2 police officers had a hold of my legs. And I says, please hold on, stop. You're gonna hurt me. And they stopped. And they helped me out, they pulled me out of the truck. And I let go of the steering wheel and they pulled me out of the truck, and there was no fighting or nothing. I was not kicking these guys. I just fell back and I grabbed a hold of the steering wheel to keep from getting hurt. Nobody ever broke my windows. When they towed my truck, that the tow truck driver would know there was no glass cleanup or anything like that, sir. And they walked away, and the only reason I called them officers to the truck, I just asked for their supervisor. I drove my truck 120 feet out of an intersection into a parking spot, which the police officer wrote in the statement. It said that Mr. Mitchell got aggravated because he didn't have insurance, and he asked if he could drive his truck to where he could have some light. I have glaucoma, I can't see, I'm 65% blind in this eye. So I didn't have any light, and my phone was underneath my brake pedal. So just trying to say that I was trying to be respectful. I never kicked anybody, and they never had to break any of my windows. That's obscene to me. I would never do that to officers. I would always, my whole life, try to be as respectful as possible I could ever be. And when they arrested me, I put up no fuss. When I got put on PR bond, you put me on PR bond, I had to report every day to the drug court and make myself available. Now, even though I was on probation already with Isabella, I made myself available to the court every day. And at one point I was homeless, and the VA ended up helping me get a place to live just before I got put to prison, okay? But I called the court every day and made myself available. No matter what, I would have went and got drug tested and anything else I needed to do. And my biggest thing was transportation, because my truck got repossessed after this incident. Of course, all that. So, but I turned myself in. When I come back here to court, you said I had a problem with Isabella, I didn't report, and that was my violation, is not reporting. There wasn't any criminal activity or anything like that, no drugs, no alcohol or anything like that. It's just, it was a non-reporting issue, and it was because of transportation. I don't have any family, anything per se that was helping me. But I was able to get a ride up here, and I turned myself into you and being respectful to the court, and especially to you and everybody, because I didn't want to have any more extenuated problems than I'd already had in my life. I got divorced about 10 years ago, and my life went downhill ever since. And I've tried to keep my crap together, but it's been hard. I am a veteran of the Army. I do have some PTSD, and I've had some emotional and mental issues. And I've done my darndest to try to take care of things the best that I can, but I realize that I need help. And through the process of being in prison, I've gone through a really good program that's helped me that way. And I've got counseling for the PTSD. I've got counseling for being able to deal with others. And that's been my biggest problem, is expressing myself properly. And that's like before, when I was here in court, I tried to say something to you and I couldn't. I just started crying. Well, that's part of working on me. And that's what I've really been able to do since I've been here, or since this last year and a half. Now, when I was on bond, my 15-year-old daughter, I got two minor daughters, tried to kill herself. She lives in Fort Wayne, Indiana. My 13 and my 15-year-old daughters want to come live with their father because they've been being abused and they can't seem to get away from it. And they need their father. And I've been trying really hard to keep myself together and take care of my necessary problems. Anything that I've had to take care of, I've been trying to take care of it as best I can. And I couldn't take custody of them while I was out on bond because I knew I had to come here and take care of this with this court. And I wasn't going to put my daughters through that more instability. So since I got put in prison, I've had no contact with them. My mother has, but they need their father. And I understand that I need to pay a debt to the state of Michigan for my actions. And that's why I'm trying to reiterate to you, I wasn't kicking anybody, they didn't bust my windows. And I'm sorry for having to drive my truck out of a busy intersection. And I went up 200 feet and parked it. I didn't run off. I went right where I told the young lady I was gonna take my pickup truck to. But to make a long story short, I'm asking for community supervision. I will do everything you need me to do. I can take a drug test today. And you know as well as I do, that drugs are available, and the people that do drugs, you can get drugs when you're in prison. Don't do that crap. Okay? I'll make myself available to you any way necessary. I will do a tether. I've been successful. I was successful on an alcohol tether for Isabella County. I can pay that. I have a CDL Class A with tankers. I've been a driver for over 21 years. I've had no issues ever as a driver, ever. No tickets, nothing. I can still work. I have bad issues in my back, but I can still work. I want to pay your fines off, and I want to be able to take care of my girls. Thank you.
Thank you, Mr. Mitchell. Ms. Goodrich, recommendations from the
Thank you, Your Honor. The defendant is 55 years old with 3 prior felonies and 12 prior misdemeanors. In 1991, he received his first impaired driving. In 2003, he had endangering a person while driving intoxicated. Then in 2021, he had operating while intoxicating third in Isabella County. While he was still on probation for that OWI third, he had a failure to appear and then also incurred the OWI third here that he's been sentencing on. And then while on bond for the OWI third here, he committed a malicious destruction of personal property, it looks like, in Hillsdale County. In the PSI, I was disappointed to read that he still believes there was no reason for the police to bother him that day. He seems to lack the insight and the severity of the public safety risks of his behavior and his choices over the years. I would ask the court to uphold the previous sentence of 3 to 5 years. Thank you.
Thank you, Mr. Mitchell. If you please stand for the court sentence.
Snap your W-2 and file.
As the prosecutor noted, in 1991, an impaired driving with open intoxicants in Hillsdale, he violated probation and failed to report to jail when ordered to do so. 1995, a felony larceny in Hillsdale, 3 years probation. While on that felony probation, he caught 2 additional charges, marijuana conviction and a domestic violence conviction. And then while on misdemeanor probation for one of those, he caught a couple more cases, disorderly person and a DWLS, although some of those are not serious crimes. This shows a history early on of Mr. Mitchell violating probation and committing crimes while on court supervision. Then in 2003 in Indiana, he has an OWI endangering a person and high BAC. He's given probation again. He violates probation and then does 330 days in jail. Again, showing that he doesn't comply with attempts at probationary sentencing seeking rehabilitation goals. He had a period of time with somewhat less criminal activity. In 2006, a disorderly person. In 2012, a domestic violence charge was dismissed. And in 2012, a felony non-support in Indiana, for which he was placed on 4 years probation. And some other charges were dismissed in 2012, 13, and 17. So there was a period there where there wasn't anything that would be particularly alarming to the court, a disorderly and a felony non-support. Then in 2020, he has a OWI third felony in Isabella. While he's on bond for that, he's convicted for lying to a peace officer. He gets 5 years probation for the OWI, violates the probation. And then while on probation, he catches this case, another operating while intoxicated. And then in 2023, he failed to appear for the violation for catching the new case, and a bench warrant was issued. So this case was on August 21st of 2022. Fact that just jumps out in this case is that while Mr. Mitchell is on probation for felony repeat OWI. He commits another OWI. And he drove off from that traffic stop and actively and physically resisted police officers. His version of what happened that day does not appear to be consistent with the documented events of that day. His plea resulted in a significant benefit to him. Several R&O charges, which could have resulted in discretionary consecutive sentencing, were dismissed. A habitual fourth notice was dismissed. As noted by the Court of Appeals, the guidelines could have been as high as 58 months with consecutive sentencing possible if he was convicted on the charges. And the max would be set by the court. Statutory max for a HAB 4 for that would have been up to life. And then while on bond in this case, which is drunk driving while on probation for drunk driving, while he's on bond for this case, he caught a new charge for a misdemeanor malicious destruction of property in Hillsdale County. You know, most folks make it through life without that kind of 30-year track record of crimes and crimes on probation and crimes on bond. And that history supports the conclusion in the PSIR, quote, in reviewing the defendant's overall history, it is found that on multiple occasions he has been convicted of new criminal acts while under supervision and has a history of non-compliance while on supervision. So what's the defendant's response to that state of affairs? Really just to blame everybody else. He says even today that the criminal justice system, in the PSI, he says the criminal justice system has mistreated him. The police had no reason to bother him on the day of the traffic stop. He even goes so far as to say he doesn't have a substance abuse problem. Well, you're convicted 4 times of drunk driving. I don't know why you don't think that amounts to a substance abuse problem. So it shows that he still, as the PSIR indicated, quote, this defendant clearly does not take responsibility for his own actions and behavior and has no respect for the criminal justice system. His behavior in prison does not appear to be problematic. That's a mitigating factor. There's only one misconduct, which really doesn't seem like a major issue. But his recent statements during the PSI process, and frankly, even his statements today, were all, you know, it's understandable that somebody in his situation would try to plead and bargain with the court for something lesser. But other than disputing the facts of the case, that's all he did. Dispute what happened and plead for leniency or some different treatment. Nothing in there other than saying he's got to pay a debt. Nothing in there about what he did that was wrong and remorse for it or acknowledgement that maybe part of the problem. I mean, if in several different counties and states and courts, you get all these convictions, maybe the common denominator, Mr. Mitchell, is not the criminal justice system. Maybe the common denominator is you and your behavior and how you respond in society, how you use substances and drive when you're using substances.
If you think this is just any regular
So I think all of this shows that Mr. Mitchell still has not internalized any corrective attitudes that would show progress toward any rehabilitation or reduction of risk at reoffending. The advisory guidelines are scored at 14 to 29 months. I continue to believe that those guidelines do not adequately take into account several things: the defendant's long history of non-compliance with attempts to rehabilitate him through probationary sentences, defendant's pattern of committing new crimes while on bond or while on probation, defendant's pattern of driving while intoxicated or impaired, especially the fact that he committed a felony repeat OWI while on probation for a felony repeat OWI. I mean, I can't state more strongly that is such a compelling factor in this case. Also, the significant reduction in the dismissal of the 4th habitual and discretionary consecutive R&Os, as the Court of Appeals acknowledged, that's a valid reason, as well as the defendant's continued expressed contempt for the criminal justice system and refusal to take responsibility for his own substance abuse related criminal activity. I certainly believe that 3 years in prison, I think there's I stated that very awkwardly. Let me just back up. I think there's an excellent case to be made, given the history I outlined, that a truly proportionate sentence, if I had the benefit of more habituals or any habituals, would be far greater than what I would impose today, what I'm able to impose today. And I would note, given the objections to the scoring issues, whether the guidelines were 14 to 29 months or 12 to 24 months would not change my decision that I believe a 3-year sentence is more proportionate than the upper end of either of those guidelines. And so therefore, I again commit Mr. Mitchell to the Department of Corrections for not less than 3 years nor more than 5 years, with credit for 515 days already served. There's $68 in state cost, $130 in crime victims assessment, $350 in court costs, which is well below the state court administrator's office calculation of the per case costs in the circuit, a $500 fine, and $200 OWI reimbursement. And Mr. Mitchell, you are able to file an application for leave to appeal to the Court of Appeals to challenge your to challenge the sentence here today on remand. If you're in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we're continuing case we had called of Sunrise Resort v. Sheboygan County Road Commission, file 20-8790MD. This is a motion for guidance and assistance in obtaining transcripts. I did discuss with counsel off the record, sort of some of the internal things that have happened with that and proposing some solutions. Mr. Lambert, anything you want to say in support of your motion?
We're looking for guidance, Your Honor, and we're very happy for the court support.
Okay, Mr. Henn, does the defense have any position?
No position, Your Honor.
All right, I'm going to grant the motion for guidance and assistance. And what we'll do is we will send to plaintiff's counsel a list of the court's approved court reporters for preparation of the transcripts for the appeal, and indicate that if counsel has any difficulty obtaining a reporter from that list who is able and willing to prepare the transcripts for them to prosecute the appeal, if they would reach out to the court, we will speak with those reporters, and we will make sure you get the transcripts to which you're entitled. I'll prepare a written order to that effect and submit out to everybody so that that can be filed to the Court of Appeals so that you don't miss any deadlines or jeopardize your appeal that way, even though I'm confident the appeal will be unsuccessful, of course, as the judge who's being appealed would always think, but you might prevail anyway. I mean, you did last time, so I've already been wrong once in this case, but we'll make sure you get your transcripts, and I apologize for the delay in an already old case. So I'll get an order out today. Anything further from the plaintiff?
Your Honor.
All right, anything further from the defense, Mr. Henn?
No, Your Honor.
Okay, you all have a fantastic day.
As well. Thank you.
All right, and we'll call next the matter of Pugh v. Newman. File 25-9151 CZ. Sir, if you can go back out through that door.
You have to come in over there.
Oh, okay, I thought it.
Good morning, Your Honor. This is a motion for entry of default judgment. Daniel Losnick on behalf of Dale and Debbie Pugh. The Pughs purchased some property on a land contract from their neighbors, Carol Newman and Martha Lonsberry. They paid off the land contract. They did not get a deed. Later on, when their daughter was trying to mortgage it to build a structure, the bank instructed them they needed a deed. And by that time, Miss Newman and Miss Lonsberry had passed. So we're asking the quiet title based upon that. I have a proposed order.
Okay, approach. All right, and based upon my review of the file, after alternative service, the default has properly been entered. The requested relief is consistent with that requested in the complaint. So therefore, I'm going to quiet title in the plaintiffs, clearing up the the title defect, and I've signed your order providing title. You can
Thank you.
receive that for filing with the clerk, and that'll be a final order closing the case.
Yep.
All right,
Thank you.
thank you, Mr. Loznick.
Appreciate it.
All right, let's go off the record for a second. And also online, calling next the case of Johnson v. Northern Water Solar Park in Sheboygan County. It is file 25-9153CH. Counsel, you want to state your appearances, please, beginning with the plaintiff.
Good morning, Your Honor. David Delaney appearing on behalf of the plaintiffs.
Morning, Your Honor. Michael Vogt appearing on behalf of Northern Water Solar Park LLC.
Good morning, Catherine Kaufman on behalf of Sheboygan County.
Morning. We have several matters noticed up today. Like we have, all right. Let's do first, we've got defendant Northern Water's motion to intervene in the appeal. And I've reviewed that motion and the response to it. Mr. Vogt, do you want to argue that motion, sir?
Thank you. Good morning, Your Honor. Again, Michael Vogt on behalf of Northern Water Solar Park LLC. I can be very brief, I think, Your Honor, with this motion. Our client has filed an abundance of caution, a motion to intervene into the claim of appeal. Our baseline position is that I think this issue may already be moot in the eyes of the court, based on the fact that Northern Water.
You're a named defendant.
Was named
and the appeal is count 10.
And count 10 makes no distinction as to which parties it is being asserted against. To the extent the court wanted to consider the motion on its merits and if the issue was not moot based on the original pleadings of the parties, we would argue, as we did in our brief, Your Honor, that we should be permitted by right, as our application was timely. The bar is low in only having to establish that our interest may not be adequately represented in the case. And while the county and Northern Waters may have some overlap in their interest, I won't belabor, but there are certainly many interests that Northern Waters would have with its business interests in this permitted project and its land use rights.
And it's not terribly unusual for the person to whom the permit is granted when there's an appeal. I mean, if an appeal is denied, the person seeking the appeal or seeking the permit files an appeal as an aggrieved party. When a permit is granted and then there are other community members or other aggrieved parties that have filed an appeal, it's not terribly uncommon for the permit holder to seek to intervene in that appeal. Is that correct?
That is correct, Your Honor, and that is the purpose for seeking to protect the permit that Northern Waters is currently holding.
Okay, thank you. And I see that you'd already filed the brief so that it's all timely filed anyway.
Correct. Just on the, if the judge were to consider it, we were to grant the motion, we wanted to make sure we were not prejudicing anyone with our briefing schedule.
Okay, very good. All right, thank you.
Thank you, Your Honor.
Mr. Delaney, your response?
Thank you, Your Honor. Having done numerous amounts of appeals in these types of cases, the court's point is valid that the applicant would appear to want to be heard on these matters. But the court rule of 7.122 doesn't seem to contemplate that.
I think I let one of your clients intervene in the appeal. They were granted a permit, their neighbors appealed, and I let your client intervene up here so that their interest in the permit could be heard and legitimately defended.
Yes, although I was not part of that appeal. That was prior counsel that intervened.
Oh, okay. Yes.
So, and there was a stipulation. The county and the applicant, the neighbor, agreed to that. And I went and looked at that issue, and I think that the Michigan Zoning Enabling Act didn't contemplate lessees, excuse me, that are leasing property. Because if you look at the statute, it says basically anybody within 300 feet that owns property would be a proper party to appeal a zoning decision, or an occupant of a building. So what they're really saying is that renters, for example, if you're renting property and a condo's coming in on a beach, let that tenant be heard. They're going to live near the property, they should be heard. And that also owners in this case. So I think the owners of the property that are leasing this property to the solar company might be proper parties, but the lessees are not. It's simply a gap in the statute in this case. And maybe they do have a vested interest in hearing that. But I don't view the court as having statutory authority under the Zoning Enabling Act or under the court rule.
Okay, thank you.
Thank you.
Ms. Kaufman, does the county have any positions with regard to the motion?
No positions.
Okay, thank you. Mr. Vogt, any
Yeah, I
rebuttal argument?
I stipulated intervention already, I'm sorry.
Oh, okay, I'm sorry. Vogt, any rebuttal argument?
I guess very briefly, Your Honor, the point I was going to make was, because I failed to mention initially, was that the county did immediately stipulate to the intervention, given the really typical track for the permit holder to desire to appeal in this. And then again, just reiterating the initial pleadings in the case, which brought my client in as a party to the count 10, which is the claim of appeal.
Okay. All right, I'm going to grant the motion for defendant Northern Waters to intervene and participate in count 10, the claim of appeal. Count 10 didn't specify which defendant it applies to. I think it would reasonably be understood to apply only to the defendant county. So I think it's properly prudence and caution for Northern Waters to have filed this motion, but I will grant it. I do think that the parties, the fee owners and the leasehold owners that are seeking a permit do have especially when the government has granted a permit, seems to me possess a property interest in that permit. That then to litigate a case to potentially deprive them of that permit without allowing them to be heard, I think could raise its own due process concerns. So I think they certainly have interests that are different from the counties. So they can't be assured that the county would protect their interests. So I'm going to grant the motion to intervene. I'll treat the appellee brief that they filed previously as timely filed. And you can submit an order to that effect, Mr. Vogt.
Thank you, Your Honor.
And then it seems to me that then we should schedule, all the briefs are in. I've received the appellee briefs from both appellees and a reply brief. So we need to schedule this then for oral arguments. I'm thinking maybe would a 1 hour time slot be sufficient for oral argument, Mr. Delaney, from your perspective?
I think so. I think the court's well versed in this file.
Okay, Mr. Vogt, you think that's sufficient time?
Yes, Your Honor. I think that's appropriate.
Yes, Your Honor.
Okay, let's see. And I know the parties are sufficiently prepared that staff told me there was a request from at least one of the parties to have that be heard today. I declined to do that for a couple of reasons. One, I need to dive deeper into all of these briefs and be adequately prepared. And two, I thought that might be cart before the horse, that we need to decide if Northern Waters is participating in that appeal. But I guess in my next civil motion day is not until April 20th. But, I don't have to wait till then. I could give you folks an hour on the afternoon of March 26th, Thursday. That's only 2 weeks from this Thursday. That'd give me time to get the briefs up, say 1 p.m.
Yes.
Would that work?
Yeah, 1 p.m. on the 26th, Your Honor?
Yes.
Yes. I can do that.
I'm also available Thursday, March 26th.
Yes, Thursday, March 26th,
Okay.
1 p.m. I'll indicate for the convenience of parties, Zoom appearances are allowed for that if you wish. But obviously, if you want to be present in the courtroom, that's fine too. And that'll give me time to review those briefs and be ready for that oral argument. All right, and we also next, I think, have defendant Sheboygan County's motion for reconsideration on the denial of summary disposition, their motion for summary disposition of count 6, the private nuisance claim. Ms. Kaufman, go ahead.
Yes, thank you, Your Honor. Sheboygan County brought this motion for reconsideration and pursuant to MCR 2.119 F3 is arguing either a palpable error by the court, which would have misled the parties in the court, resulting in a different outcome, or secondly, that within the court's discretion to correct mistakes, preserve judicial economy, and minimize costs, that the court would have also the authority to rule for the county on this motion for reconsideration. As argued in our brief in support of our motion, Sheboygan County is a governmental agency immune from tort liability if we are engaged in the exercise or discharge of a governmental function. That is what the county did when they reviewed and ultimately approved the special land use for Northern Waters. So again, we were exercising a governmental function as a governmental agency. You know, the Governmental Tort Liability Act, MCL 691.1401 at SEC, only provides 5 exceptions to governmental immunity, none of which apply in this particular case. Therefore, we feel we're governmentally immune and we should be allowed to not be found responsible for any private tort claim that plaintiffs may have brought. Additionally, to the Government Tort Liability Act, our case law clearly distinguishing that issuance of a permit is not enough to create a nuisance sufficient to impose liability. That's a case that was cited in our brief in support. Curia Hughes versus West Bloomfield Township 196, Mishap 175. So that case says, in addition to saying we can't be found liable for issuing permits for a nuisance, that a governmental entity is not liable for damage caused by a nuisance unless the entity has either created the nuisance, owns or controls the property from which the nuisance arose, or employed another that it knows is likely to create a nuisance. That's Curia Hughes, again, citing McSwain versus Redford Township, 173 Mishap 492. Plaintiffs in their reply brief to this motion cited a case called Haxma versus City of Grand Rapids. That was 247 Mishap 44. And in their brief, they cited the fact that this case apparently states that while it remains unclear whether a nuisance per se exception to governmental immunity exists in Michigan, and they went off of that and just kind of stated that sentence. They stated the wrong citation of the case, so I'll provide it for the court. 247 Mishap 44, 2001, Court of Appeals. The Haxma case dealt with sidewalk liability. Sidewalk liability is one exception to the Government Tort Liability Act. And while it did address nuisance per se, and that statement was made in the case, it then goes on to say and define a nuisance per se as an activity or condition which constitutes a nuisance at all times and under all circumstances without regard to the care to which it's conducted or maintained. That's, as we all generally understand, what a nuisance per se from law.
Well, there was a nuisance per se count in this action that this court already granted dismissal under summary disposition. Is that
That's correct. And I think what plaintiff might be arguing is that this project will be a violation of the zoning ordinance, which we disagree with, and obviously the appeal will be heard. So for those reasons, governmentally immune and case law under Curia accused that issuing permits alone is not enough to create nuisance sufficient to impose liability, we move this court to dismiss, grant our motion for reconsideration and dismiss count 6 private nuisance against the county.
Mr. Delaney, your response?
I agree with counsel, and I think the court can't disagree that governmental immunity is broad for agencies such as this, but it reflects tort liability. And I think one of the key phrases that counsel provided to the court was liability for damages. We don't seek money damages against the county for the granting of the permit. We do seek equitable relief in this case, which is a finding by the court that this is a nuisance. And the court is correct. The nuisance per se claim was dismissed by the court, but that was hinged on PA 233. At that time, I had not filed my brief on appeal, which is the count 10 of this case, reflecting whether or not this particular project violates the county zoning ordinance. We will be looking at that in a couple of weeks. And I wouldn't have had time to amend my pleadings to allege nuisance per se in this case. And also any constitutional claims would survive in this matter. So I would ask that the court take it under consideration, hear the appeal in a couple of weeks, and decide whether or not a nuisance per se would still be viable in this case. But we don't seek damages, we don't seek liability, we do seek equitable relief in a finding by the court for an injunction that it violates the zoning ordinance.
And you could obtain that against the, I mean, if your claim that this project does or would constitute a private nuisance, you could obtain that injunctive relief against defendant Northern Waters, right?
Yes, and I suppose, right, if the court granted that relief, would it also apply to the county? And maybe
Well, the county's
not.
I presume the county's not going to go out there and start building solar panels.
Correct. That's right. That's correct. And again, equitable relief is an exception to the statute in this case.
Okay, thank you, Mr. Delaney. Ms. Kaufman, does the county have any position with regard to this motion? I'm sorry, Mr. Vogt, do you have, does Northern Waters have any position with regard to this motion?
No, Your Honor.
Okay, Ms. Kaufman, any rebuttal argument?
Just to say, obviously the county's not going to go build the project, operate the project. They're not going to be doing this. Thank you.
Okay, this motion for reconsideration sort of cleans up something that in our fairly detailed motion hearing on summary disposition recently, I think, I forget who brought it up, but somebody brought up during the argument that, well, maybe the county shouldn't be part of one of the surviving counts, that being private nuisance, since they're not the ones that would actually be creating the nuisance. They're just granting a permit. Whether the permit is properly granted or not is subject to the count 10 appeal. But because that really hadn't been briefed, I indicated that, well, that would probably require a separate motion. And so then there was a motion for reconsideration of the denial of the county's motion for dismissal of count 6, the private nuisance. I've reviewed the briefs, heard the arguments today. I agree that then the county can't be sued in tort for the granting of a permit. Private nuisance is a tort action. And so the county, by granting a permit, if they have wrongfully granted it, there's an appeal, and that appeal is pending, and we've scheduled it for oral argument. And if the permit was not properly issued, it can be reversed by this court. If the county were to violate people's rights in the way that a matter is handled, they can be sued for that, and they were. And this court dismissed those counts, summary disposition. Here, the county is saying that they are immune from tort liability for the granting of a permit. And I think that's correct under the law. And it's a common sense position that the county, in granting a permit, they're seeking to apply their zoning ordinance. They're not the ones out there with a shovel creating a project and creating a nuisance for the people who are claiming that it's a nuisance. Nuisance lies at the common law to say, hey, somebody is interfering with my use and enjoyment, my right to use and enjoy my property peacefully. In this case, the parties that would be allegedly interfering with the use and enjoyment of their property would be Northern Waters by building the solar project. It wouldn't be Sheboygan County. So I'm gonna grant the motion for reconsideration, and on reconsideration, dismiss count 6 private nuisance as to defendant Sheboygan County under 2.116 C7 governmental immunity. And Ms. Kaufman, you can submit an order to that effect. And that means that right now, the procedural posture is there are 2 counts that remain. Count 6, private nuisance only against defendant Northern Waters, and count 10, the appeal as to both defendants. We also have a third motion up today, Mr. Vogt, that is Northern Waters motion for a stay pending appeal of the denial of summary disposition of private nuisance STU.
Yes,
Go ahead.
Watch what happens to brown fat when you drink this, rosemary.
Thank you, Judge. Yes, as explained in our motion in brief, Northern Waters will be applying for leave to appeal the court's decisions on an interlocutory basis with respect to the denial of the motion for summary disposition and reconsideration, specifically as it pertained to the plaintiff's private nuisance claim. The request, in simplest terms, Your Honor, is to stay and hold in abeyance the anticipatory private nuisance claim during the pendency of our time with the Court of Appeals with our application. Important to note, we are not seeking to in any way impede the progress of the plaintiff's pending claim of appeal in count 10. That is our position, is that should move forward as it's been scheduled for oral argument now on March 26th. We did receive an objection on Friday from the plaintiffs. The only stated basis for the objection in the written response, at least, was alleged inadequacy of notice under MCR 1.108. Our position is that the court rules actually were complied with, and that today is counted under 1.108 on the day of the hearing. And so today would be day 7. From my experience, I've been encountered countless times with motions filed on a Friday for the next Friday or Monday for the next Monday. So I didn't think there was anything unusual about that, but setting that aside.
Well, that's interesting, 'cause under the court rules, and I think I agree with you on that. And our court will this summer, we're expected to move to MyFile, e-filing system. And as I understand it, when MyFile is in place, you can file up to 11:59 p.m. and it counts as being filed that day.
I think that's right.
All right, so maybe that's a gap in the court rule. You know, it does effectively shorten notice by up to a day for folks that when there's MyFile. But as I understand, I think that's just a feature of the system right now.
Yeah,
I think it would not serve the interests of judicial economy to make you notice up and come back later for us to do this motion to stay. So I'm going to hear it today.
Okay, thank you.
But what I'm concerned about is I don't think that your position on the private nuisance is anywhere near frivolous. You know, I think that you've got many colorable arguments about that. My denial of the summary disposition was because it was on the front end of the case, and that the non-moving party did come forward with enough facts to at least allow it to go forward. And then to stay the case to seek an interlocutory civil appeal, it seems to me that it's possible that I'm so wrong in that ruling that they will get involved. I'm not discounting that, but interlocutory civil appeals are not terribly common, are they?
Understood.
Usually the Court of Appeals denies for the failure to persuade of the need to intervene at this point, and says, let you guys sort it all out because some of these cases settle. Why do we want to jump in a case before the case is concluded in a civil matter? Why do you think that this case is different, and that we should put this on hold to see if the Court of Appeals wants to get involved?
Sure.
Interlocutory.
A few at a high level, as the court rules allow, under the interest of justice and judicial economy, a stay would be appropriate. I can talk about that in a moment. But why do I think the Court of Appeals will look at this case and say, yeah, pull this one up, we need to look at it midstream here? I think because it is uniquely postured in the circumstances. And, you know, as Northern Waters respectfully disagrees with the court's prior ruling, our review of the case law cannot find any anticipatory nuisance claims in this setting.
Okay, so that makes it different.
That it's a real departure from traditional zoning law and the appeal process and the way to challenge permits that are issued by zoning authorities. And the only times we've seen anticipatory nuisance claims recognized in any way is when there was something imminent. For basically the same standard that's applied to injunctive relief, that it is an imminent, nearly almost certain harm. And we quote the language from those cases where it's the only times the courts have recognized anticipatory nuisance. And the bar is so high it has to be a quote practical certainty that the nuisance condition is about to exist. And in this case, where there is no project that exists currently, and they do not claim any damages, as council mentioned earlier, that they're not currently damaged in any way, they're seeking a declaration from this court to maintain the status quo right now and allow the Court of Appeals an opportunity to look at this. I think very important, it's a legal issue in the body of zoning law, would justify them stepping in and if the court is not inclined to grant the stay, it would be requested at the Court of Appeals. And I do think that based on my experience in zoning law, they would think that this is worth examining on an interlocutory basis. And secondarily, Judge, the circumstances are also that we have 18 individual plaintiffs in this case, with different individually owned properties, varying distances from the future project site. If we march off on discovery after today, that's, really it's on Northern Waters to vet these claims from 18 plaintiffs with all somewhat, I was not so somewhat generic, identical claims that need to be vetted at great length. We're talking 18 depositions. If there's medical issues, we're talking IMEs, all things that might be totally avoidable if the Court of Appeals says, you know what, we want to take a look at this and, give another shake at this important legal question.
Okay, and a stay kind of cuts both ways a little bit. I imagine your client would like to move forward with the project without unnecessary delay. And if the Court of Appeals says, well, this is an intriguing issue, but we're going to wait till the case is resolved, then you come back here and now we got to so now that just builds in more delay.
It does, Your Honor. And I agree.
I know there's no injunction that's been issued in this case, but I get the impression that there's no incentive or movement by your client to begin the physical project until the legal path is cleared.
Well, for one thing, Your Honor, the permit that we hold is currently on appeal, right? I mean, like to go get our building permit right now, it's on appeal before this court. They could seek leave to go beyond this court. So, so under no circumstance could we go right now on that because it's pending appeal, or would we move forward with that? So the court's correct in that regard. So this is not in any way an attempt to delay, because delay is not in my client's favor.
No, in fact, that would cut maybe toward so maybe the plaintiffs wouldn't, I don't know if I know they objected on notice. I don't know whether they object on the merits or not.
I did not receive response to my request for concurrence substantively, and would ask the court to, in the interest
would be that it wouldn't prejudice or hurt them anyway, because the project hasn't begun. So there's no nuisance that's ongoing right now.
That's correct. And we limit our stay to the resolution of the issue on appeal. The Court of Appeals resolves the issue or denies our application. Then we'd be back here, before the court.
One final question for you. What were to happen? And again, I only briefly looked at the appeal briefs. What were to happen if I grant this stay and you're pursuing an interlocutory appeal of the private nuisance action, and then on review on the merits, I grant the appeal on the permit, and then the permit goes away? What would that do procedurally? I guess, well, then you would have appellate remedies on count 10.
So if
that wouldn't be a final order then, would it? Because count 6 is, I mean, by combining the appeal in the litigation, that would be a strange.
So if the appeal overturned the permit?
Yes, sir.
Okay, so now the permit has been vacated. We vacated that decision, so that's gone.
And your client would seek appellate review of that?
We would, I'll say presumably, yes. I think that.
Want the fastest?
For the time being, the private nuisance claim, it's underpinned on the fact that this was approved, because there is no construction.
Right, because if there is no permit, then
there is no private nuisance claim, it becomes moot.
Okay.
Yeah.
Okay. All right, thank you.
Thanks, Judge.
Mr. Delaney, your position?
The court has already addressed the timeliness of this matter. If you, with my file, if I'll start getting motions Monday night at 11:59, and my answer is due 3 days before the hearing, that leaves me 3 days during that week, assuming this is my only case. I know these are busy practitioners. It's going to wreak some havoc if my opponents find out that we can 7-day these things. And I'll be,
we can 6 a.m.
we can 6 a.m., right. And it was a 7-page brief. There's a lot in this brief to address, but if the court will allow me to simply orally address it, because I was able to read over the weekend what I wanted to about this. Okay, good. Because I certainly don't waive the merits of this matter. And I think the court rules probably needed to be updated in that regard. Anyway, just a final note. What if he had mailed it? We have an agreement for electronic service, which is great. But if he mailed it with the post office, I would have got it Thursday. But in any event, if I was lucky, right. So the court rules were probably drafted in the 60s when we had real mail delivery. No disrespect to the mail delivery.
No, I have had untold headaches on the bench with regard to notice with postal delivery in the last 3 years.
Yeah, and if you look at the recent holiday, I think President's Day, we're in my jurisdiction, it's Grayling, Kalkaska, and Gaylord. So the court issued a decision on a Friday, but the following Monday was a holiday. They didn't get it to the following week, but in any event, we have some of those issues here. On this particular motion, I think the court has appellate experience and counsel may. I certainly have been in the Court of Appeals for well over 20 years. I think the interlocutory appeals are rarely granted because the court has to invade this court's docket and make a decision. And what's not discussed by counsel is discovery. That's really what he's asking to freeze in this case. And
absolutely. Yeah.
Right.
But can I ask you, so yes, because I raised the issue that I do think interlocutory appellate review in civil cases is unusual. But isn't it admittedly unusual for a court to entertain a claim for anticipatory nuisance as well?
Well, we cited case law in which the Court of Appeals recently ruled on a future harm case. That's in the briefing that was filed with this court. So for example, let's say during discovery, we determine and find out that the glass composition of these solar panels will contaminate the lakes, rivers, and streams of Sheboygan County. Now our damages are no longer speculative, but they're likely improbable. So the Court of Appeals would be saying, and we don't even have a scheduling order from the court, although I could begin discovery. I haven't yet because we've certainly been busy in this case. What am I going to find out when I engage in discovery that would benefit the court in determining whether it's a nuisance or not? So the Court of Appeals would be saying, because that's the only basis that you allowed that claim to go forward was discovery. I'm well aware of the court's comments about future harm. So the Court of Appeals would be saying, we're going to invade Judge Gauthier's docket, and we're going to find that no amount of discovery could possibly lead itself to a viable claim. When that court has already ruled on future harm recently, which I cited to the court. Also, we're going to be looking at a long delay here. A delayed application, if it's accepted, is then determined to be an appeal of right.
Yeah, and then we're looking at probably a year.
18 months.
So, but how would that hurt your clients when a shovel hasn't broken a single inch of earth?
Well, the discovery, that's going to be substantial in this case. And so that could change.
But you would still get it if you prevent. I mean, if Northern Waters doesn't succeed on appeal, you're still going to get through all that discovery. I'm just grappling then with how does this harm your clients? In fact, isn't it? There could be an argument that it's sort of in your client's interest just to continue to delay this project happening.
One of the factors the court has to look at in the appeal has two records, actually. One is simply the zoning record. You have that extensive record. But the other part is aggrieved party. Now, we're going to have oral argument now in a couple of weeks, but and I think that they'll meet those burdens on aggrieved party because the standard is so low. But would discovery be a factor there? If Northern Waters was going to appeal any decision this court made on the appeal, but during that time in discovery, I found more information. So now aggrieved party has reared its head as being really important because the one owner who's completely surrounded by the solar panels in this case could find out in discovery that he's really an aggrieved party because of the composition of these panels, because of contamination and things like that. So we think discovery is very important. I see the court's point that delay would be good because it delays the project. I do want to make a note about appeal processes. The MTSC is the only case that I know in the Court of Appeals, and we cited that in our briefing, the MTSC order. That was filed November 8th of 2024. They still don't have a decision. It's on case call for April 15th. And that'll be, if they decided in May, it'll be 18 months. So as important as allegedly, and that case is full of amicus curiae briefs, as that case is, the Court of Appeals still took 18 months, or they could take longer. 18 months is just their guidepost. They may not decide that case for another 6 months. So the bottom line is, to the court's point, yes, okay, so it's delayed. What's your objection? It's the discovery. And does that impact a aggrieved party? I don't know. But that's our real objection, is that they're prohibiting discovery, which was the premise of the court's ruling to allow the nuisance claim to go forward.
Okay, thank you, Mr. Thank you. Ms. Kaufman, does the county have any position with regard to this motion?
No, Your Honor.
Okay, Mr. Vogt, any rebuttal argument?
Thank you, Judge. I wanted to respond to just a few things. One, on the topic of the Court of Appeals reluctantly granting interlocutory leave because it has to interject itself into the court's docket. I wanted to note that based on the court's prior ruling, this anticipatory private nuisance claim is the sole remaining claim as it pertains to Northern Waters outside of the appeal. So there is no holdup, there's no prejudice on any other claim preventing it from proceeding. It would only apply to the one claim that still remains in the court. Again, the issue of judicial economy is substantial here. We're talking a lot of, I knew the type of discovery we needed to do to vet these claims, to disprove them. And that will be substantial, immense, and cost not only on my party, and it's not pity Northern Waters. This is time and resources and cost that 18 plaintiffs will have to go through that may potentially be entirely avoidable.
And the scope of the discovery is going to be significant, not just in the number of the plaintiffs, but it sounds like the plaintiffs' claims are going to require overstate it, but almost a ruling that they're trying to say that the mere construction and existence of solar panels constitutes such a harm to any nearby properties that it shouldn't be allowed to happen.
And finish the sentence, even when, Your Honor, it's been 50 findings of fact found that it met all the special land use standards, and it meets all the standards of PA 233, where the legislature has determined it does not constitute a public threat to the public health if it meets these standards. So to finish that sentence, anticipatory nuisance claim of a project when it's built, that meets all special land use standards and meets a standard that the legislature has said deems it to be not a threat to the public health. So it is the task that's been levied upon us with this anticipatory nuisance claim is to prove a negative, to show us that this is not a nuisance.
Well,
so that's why we'd ask to stay. And so that's the discovery we have to do. From what I just heard from Mr. Delaney, though, is very troubling, because it lays bare the fact that what has been done here is said solar panels are hazardous, and if we get the chance to go fishing, we'll tell you why later. He said, oh, we don't know what's in these panels. That's the whole problem here. It's everything against the wall. Let us go fish, and maybe we'll find something that proves a nuisance later. That sentence right there lays it all there. And I'd ask to stay this while the Court of Appeals looks at this issue.
Okay, thank you.
Thank you, Judge.
Well, the defendant Northern Waters is seeking this court to enter a stay of the litigation of count 6 only, which would allow the appeal count 10 to continue. It's procedurally different than the civil action component to this case, and stay that to allow them to seek interlocutory appellate review. It is unusual for the Court of Appeals to intervene in a civil case on an interlocutory basis, especially I think when summary disposition is denied pre-discovery. So I think that's a pretty narrow window of type case. However, it is unusual for a court to go forward with a claim of nuisance in the future. Nuisance is a tort claim, where, as I said earlier, a property owner has a right at the common law to the use and enjoyment of their property. And if their neighbor or somebody, if somebody is interfering with the use and enjoyment of their property.
1/8 plus 1/8 equals 1/4. 1/2 is bigger than 1/3, and 1/3 is bigger than 1/4. 1/2 is.
They get to go to court and say, hey, somebody's interfering with the quiet use and enjoyment of my property. I either need money to be made whole, or I need you to order them to stop it, or both. it is very unusual for a claim to say, well, I'm pretty sure my neighbor is going to interfere with the quiet use and enjoyment of my property. As I already stated when I denied the motion for summary disposition on these facts, I think that claim should be allowed to go forward. That's why I denied the motion to dismiss. However, I think the defense position that that's highly unusual and that the evidence to allow it to go forward is fairly attenuated has certainly some degree of merit. It's hard for me to understand how allowing the Court of Appeals to take a look at this right now before both sides expend thousands upon thousands of dollars in hours, hundreds of hours in litigation. It's hard for me to understand how that hurts the plaintiffs. So on the whole, I'm going to grant the motion to stay count 6 pending interlocutory appellate review. And count 10 will continue to go forward. And Mr. Vogt, you can submit an order to that effect. I was going to go forward and enter a scheduling order, but we don't need to do that since the stay is granted. And then I guess that would leave us the next time we'll be here is the oral argument on count 10. Mr. Delaney from plaintiffs, anything further that we would need to accomplish today, sir?
On the granting of the stay, since this will go up to the Court of Appeals, does the court need to address bond in this matter? With the notice of this, I had not an opportunity to review the statute or court rule to see if that would be a requirement.
Oh, well, I would indicate that there'd be no bond that would be required on appeal because this is a question of public interest and also it's equitable and interlocutory, injunctive relief being requested and not damages. So I think there's no need for a bond. Anything further from Defendant Northern Waters' position that we need to accomplish today, Mr. Vogt?
The only quick question on the oral argument on the 26th. Is it we all be here in person or we all do Zoom or does the court allow it?
I'll indicate Zoom will be authorized for any party that wishes to argue by Zoom and in person is fine. I can do a hybrid hearing, no problem.
Okay,
so whoever wants to be here can be here. If you want to Zoom in, that's perfectly fine.
All right, thanks, Judge.
Okay, Ms. Kaufman, anything further?
Nothing further, thank you.
All right, thank you all very much.
Thank you.
I'll move into the family division docket, so I'll end the live stream. This morning, first case is People of the State of Michigan versus Spencer Hope. It's filed 26-7142 FH. Counsel, you want to state your appearances, please, beginning with people.
Melissa Goodrich, Wayne County Prosecutor.
Daniel Price with the defendant who sits to my right.
Okay, good morning. All right, and we have, this is scheduled for an arraignment and pretrial for a scheduling order, and there's also a bond motion that's been noticed up. So for purposes of the arraignment, Mr. Price, if you had opportunity to review the charging document with your client?
Yes, I had, Judge. We would waive the reading of the charges, and my client elects to stand mute, or mute, excuse me.
All right, so we'll enter a plea of not guilty on his behalf to the 2 counts of felonious assault, domestic violence, 2nd, child abuse, 4th, and reckless driving. Is a forensic center referral requested?
I'm sorry?
Is a forensic center referral requested as to competency or criminal responsibility, sir? Or no?
No, not at this time.
What would be the estimated length of trial?
Probably 3 days.
Okay.
Yeah, I do have one of the victims in the Zoom waiting room that wanted to attend via Zoom.
Oh, okay.
And the victim advocate.
Okay, I do see iPhone, so thank you all. And that person.
Be alleged.
we could schedule this for, I know different, Mr. Price, I haven't had a case with you. Different counties call them different things. Here we call it a docket call, like a jury status conference or a pretrial that we schedule just to touch base as whether the case is resolved or whether there's any motions that can be noticed up that same date and time, or whether we need to put it on our trial docket. So we can come back for a docket call on April 28th. I do allow, if you need appearances by Zoom, video conferencing, or in person is fine. Is morning or afternoon better for you, sir?
Either or, doesn't matter to me.
Okay, why don't we put this then for April 28th? Oops. At 10:50 a.m. And I'll indicate that Zoom appearances would be authorized. And then anything further from the defense in terms of scheduling order, sir?
No, that would be for the purpose of the status, and then we would set trial after that. Is that?
Yes, sir. Unless you know for certain, you just want me to put it on our trial docket and get some dates.
No, I just want to make it that it's clear in my mind.
Absolutely.
Thank you.
Okay. Ms. Goodrich, anything further from the people for scheduling?
Thank you.
Okay, Mr. Price, through predecessor counsel, Mr. Hope had filed a motion to address bond conditions. Did you want to press that motion today, sir?
Yes.
Okay, go ahead.
Thank you. The district court here in this county set a bond in on November 3rd, 2025. That conditions of bond prohibits contact between my client and his daughter, who's a minor child. Excuse me. My client is going through a divorce in Emmett County. And on January 28th, there was an amendment or amended PPO order that's connected to this case that allowed my client to have at close contact with the mother of the child solely concerning the child, and with the child to exercise parental rights via video chat, no in-person, no phone calls, just through at close. Prior counsel did get a stipulation to that amended PPO by the divorce attorney for Ms. Hope. Prior counsel in this court attempted to obtain the consent of the prosecutor to amend the bond here. She's indicated to me today, and he indicated in his motion, that she could not agree based on the alleged victim statement to her. We're only asking that my client be allowed to exercise parenting time with his child. If he could set it up with his child, he would. He wouldn't need to contact the mother of the child. Unfortunately, that can't be done.
Isn't the child one of the
alleged victims?
One of the alleged victims in the case as well?
Correct, Judge. I mean, after getting involved, because I'm now handling the divorce case.
Okay.
There's a couple of motions in that case. Excuse me. Too many years of smoking. One of which is to set aside a restraining order. The other which is to defend an alleged violation of that restraining order. After reviewing all the facts and talking to witnesses, I will show in that court that the basis of the restraining order, as well as the motion for show cause, is based on fraudulent statements by the alleged victim in this case. My understanding of this case is my client was basically set up. He at no time admitted to any of the allegations against him. The police on the scene pressed him 2 or 3 times, and he said the same thing each time. I don't think he poses a threat to his daughter.
Okay. Anything else I need to know to understand your position?
I'm sorry.
Anything else I need to know to understand your position?
If you'd like, I can read that amended PPO to specifically state what we're looking for.
No, that's fine. I mean, I think I understand the requested relief.
Okay.
Right, thank you. Ms. Goodrich, people's position.
Your Honor, I would ask the court to deny that motion. That would be unusual in a victim case. This child is a victim in the crime. It's not just a child that they have in common, separate from this crime. She was part of it. The court has the affidavit. This was where they were pursued by Mr. Hope in a vehicle. So there is cause for concern of having any contact at this time. The victim is concerned as the mother for having any contact with her child at this time. I did reach out to the divorce attorney as well to see if there was anything unusual about why they did this in the PPO. There was nothing to, I guess, change my mind as to wanting a no contact with both victims in this case.
All right, thank you. Mr. Price, any rebuttal argument?
No, only to reinforce the fact that the divorce counsel stipulated to the amended PPO order.
Okay. I mean, and there's different considerations in a divorce case and in a PPO case and in a criminal case. There's a lot of overlap. The Venn diagram would, have a lot of overlap, but there's, some considerations that are different. The requested relief is to amend the bond conditions to allow video contact only. So that would, address any concerns about the physical safety of the child. But in a criminal case, there's some considerations that even go beyond that. I understand Mr. Hope's, presumed innocent, and it's from the statements of counsel, he takes issue with some of the allegations or the context of the facts that are alleged here. And he's got all his rights to pursue those and have a jury determine those things. But he's charged, and there's been a probable cause determination with child abuse and felonious assault with this minor child as the alleged victim of that. It would be quite unusual for a court to allow contact with that victim, even by video, for a child to have witnessed what was alleged. If those are true facts, at this point, there's a probable cause determination of them, would be a difficult circumstance for that child to process. So I would think that there's a risk that even video or telephonic contact with Mr. Hope would present a risk of undue emotional, psychological harm or pressure on the child regarding what her testimony might be. So I'm going to deny the motion to amend the bond conditions. We'll see you on April 28th at 10:50 a.m., Mr. Hope.
Thank you, Judge. All the other conditions of bond remain the same.
Yes, sir. And I'll just note that on the criminal scheduling order so that there's no proposed order that you need to submit. All right, thank you.
Thank you.
Can we go off the record for a second? Mr. Price, could you approach? Our live stream, we have one more criminal matter. It's People of the State of Michigan versus Gloria Jean Dabbs, file 25-7096FH. Counsel, you want to state your appearance, beginning with people?
Melissa Goodrich, Blount County Prosecutor.
No, Nightingale, for Miss Dabbs, who appears, I think in person. I can't see her though.
Yes, she is in the courtroom. And so, Mr. Nightingale, do you she did tell us that she spoke with you on Friday. So do you think this is fine to do it in this hybrid way, or do you want us to put her in a jail Zoom room to facilitate any breakout communication, or do you think we're good to go?
I think we're good to go, Judge.
Okay. All right. And this matter had been scheduled for a trial. It was removed off the trial docket based on an anticipated plea. And I think because of the jail cap on that and her credit, counsel wanted to move the hearing up to today for entry of a plea and sentencing. Is that how we're going to proceed today, Mr. Nightingale?
That is correct. Thank you, Judge.
Okay, and I do have the plea agreement and advice of rights. All right. A letter from Pastor Jones about her participation in jail services. All right, so Ms. Dabbs, this is going to be, and Ms. Gooders, do you have an amended information or no?
I do not, Your Honor.
Okay, and that's 1 year and or is it a $200 to $500 fine?
I believe so. I can pull it up here in the meeting.
All right, well, Ms. Dabbs, under this.
I'm sorry, 200 to 1,000 and 5 days to 1 year in jail.
That's what I'm saying as well.
Okay, thank you. All right, so Ms. Dabbs, by this plea agreement, you'd be pleading guilty to an amended charge of operating while intoxicated, second offense. And that would be a misdemeanor punishable by 5 days to 1 year in jail and or a $200 to $100,000 fine. Do you understand that maximum penalty?
Yes.
Did you read and understand the rights listed on the advice of rights form?
Yes.
You understand that that form lists the rights that you give up by entering a plea instead of going to trial?
Yes.
And is that what you wish to do?
Yes.
The plea agreement provides in exchange for your plea to the misdemeanor charge, the felony would be dismissed. And there's a sentence agreement that you serve 6 months of incarceration, that it'd be a straight jail sentence and credit for the time that you have been serving. Do you understand the terms of that plea agreement?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you to make you plead?
No.
Is entering the plea your own free choice?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No, Your Honor.
All right, knowing all this, Ms. Dabbs, how do you wish to plead the charge of operating while intoxicated, second offense?
Yes.
So back on July 8th of 2025, were you operating a vehicle in Sheboygan County?
No.
Where were you operating a vehicle?
Judge, if the complaint date is actually incorrect. I believe the date was 7/3.
7/3, okay.
So I think that's why she says no.
Okay, great. On July 3rd, were you up, and Ms. Goodrich, is that fine?
That is fine.
Okay. On July 3rd of last year, were you operating a motor vehicle in Sheboygan County?
Yes.
Okay. And were you operating that vehicle on a public highway, that being North Straits Highway?
Yes.
Before you operated that vehicle, had you consumed alcoholic beverages?
Yes.
Did you have some contact with police officers?
Yes.
Did they end up giving you a test to determine the amount of alcohol in your body?
Yes.
Do you remember the results of that test?
No.
Were they above the legal limit of 0.08?
Yes.
Okay, and you don't challenge that test result?
No.
And at that time, did you have a previous conviction for operating while intoxicated? Looks like most recently back in 2007 in Knox County, Tennessee.
I think the actual arrest was 2003, but conviction in 2007.
Okay.
But yes.
Okay. And Mr. Nightingale, that of course would be outside the 7-year window for an OWI second, but she's charged with a greater offense of the third within any period of time. So do you consent to the entry of the lesser offense?
I do. Thank you.
Okay. All right. Are you satisfied with that factual basis, Mr. Nightingale?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
All right. Ms. Dabbs, I find that your misdemeanor plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea, and we can proceed to immediate sentencing then. By my calculation, Mr. Nightingale, I think I've got her at 152 days credit as of today, according to the jail log. Anything you want to say on her behalf?
Yes, Your Honor, please. So I do have her at 153, but I think one day, one way or the other is not going to matter at this point. Asking the court to accept the agreement of the parties here. Ms. Dabbs comes before the court, I believe 70 years of age. She has extremely limited criminal history. Her last conviction was about 20 years ago, and I think she's informed the court that her recollection is that's actually a prior case that was dismissed and then refiled. And so it looks like it's later in time, but when in fact it was earlier in time. Nonetheless, 20 years, I think, since she's had any history like this, has no prior felonies. This was an incident from July 3rd of last year. There was no crash here. The 911 call does report some erratic driving behavior, but none was actually observed by the officer who pulls her over. Ms. Dabbs was fairly compliant, acted appropriately with the officers. Her blood alcohol content was a 0.113, so not a super drunk, but above the 0.08, as the court's already asked her about. So nothing particularly concerning about the facts of the case itself. I'm sure that the court, is obviously and always concerned with prior OWIs. We hope that since she's had 20 years since that last DUI, since this 6 months of jail is the top of the guidelines for her on an OWI third, that the court will accept this agreement, will consider it appropriate and reasonable under her specific circumstances, not place her on probation. She is on a fixed income. As to her person, Ms. Dabbs obviously received that letter from the pastor at the jail. She's obviously at least attempting to take her time in there seriously and rehabilitate not just herself, but some of the other people, the other folks that are in there. She is a lifelong educator, and I think that's not ever something that's going to leave her and something that she's taken to the jail with her. Trying to pass on her experience, to the younger folks that are in there. This case itself, I think Ms. Dabbs was certainly dealing with an amount of grief that she has not probably, really acknowledged or fully dealt with at this point. Her husband passed a few years ago at this point, I believe, but it was like a long and drawn out passing. I think that he had some sort of cancer, and through that treatment process, she was essentially bankrupted. Almost lost everything. Thankfully she's been able to keep her home, and that I think has been a big wake-up call for her. This period of incarceration almost cost her home, and everything inside of it. And I don't think that this court's going to see Ms. Dabbs again, at least in this capacity. She is a good and fairly law-abiding member of the community, and I hope that this is the last time that she has this type of run-in with the law. We are very grateful for the plea agreement that Ms. Goodrich and I came to. I think that it fairly and appropriately deals with what happened here, and ask the court to accept the same. Thank you.
Thank you, Mr. Hankiel. Ms. Dabbs, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or no? Okay, that's fine.
I can't think of anything.
That's fine. Any recommendations from the people, Ms. Goodrich?
Yes, Sean, I'd be asking the court to follow the plea agreement. The beginning of this case was rough. Ms. Dabbs kept violating her bond, but yet didn't want to go to rehab or admit that she had an issue. I was really happy to see this letter from Pastor Jones that she's turned the corner and has invested in achieving sobriety, and also had the empathy to help others along the way. So I would ask the court to follow the plea agreement. Thank you.
Okay, thank you. Well, Ms. Dabbs, if you please stand for the court sentence. Well, Ms. Dabbs, you've got some prior convictions. They were a long time ago, which is why you've got this outcome here today, which I am going to follow. I share the prosecutor's concern about, that you seemed to be either unable or unwilling to stop drinking while you were on bond for this case. That does give me some worry about future. And with the history that you have now with a recent drunk driving, if you come back in front of me for a drunk driving, it will almost certainly be sending you to the state prison, which at your stage in life, I guarantee you, you do not want that to happen.
No,
So,
I do not, but may I say something?
sure.
I did not drink on bond.
Why did we revoke your bond?
They were dilutes.
Oh, okay. Well, then you were, yeah, okay.
But,
That worries me even more.
but there was, according to several people I've talked to, it's from the caffeine that I was drinking. And unfortunately, eating pineapple, which I didn't know would eat the protein, it's supposed to keep it from.
So, Ms. Dabbs, I don't want to cut you off, but the judge is about to accept the agreement of the parties, and so
Yeah,
I would not
don't
make.
worry, I'm not gonna. Yeah, I'm not. He's worried because you're like giving me excuses, and that's usually not a good recipe for me to follow the agreement. But I'm not going to hold that against her. I'm going to follow the agreement, Mr. Nightingale. But,
Thank you, Judge.
But Ms. Dabbs, I guess I just want to tell you, I'm going to follow this agreement, but I'm concerned that we're not done with you, and I guess I just want to promise you, you want to be done drinking and driving. I hope you're done drinking. But, you know, if you want to get as drunk as you want in your own home, that's not going to be illegal for you. It's going to be bad for you given your history, but that's up to you. But if you get behind the wheel after you've been drinking, I promise you, you and I are going to have a very different interaction.
It won't happen again, Your Honor.
Okay. I sure hope you're right about that. I'm not in charge of that. You are. Okay. So understand, if in a year or two, I'm sending you to prison for another drunk driving, that's not my fault. That's going to be your fault and your decision. All right. Well, given the number of prior drunk drivings, I'm a bit reluctant about this, but the fact that they are so long ago and there's been such a length of time without problem, I'm going to follow the agreement this time and sentence you to 6 months in the Sheboygan County Jail with credit for 152 days credit. There's a state cost of $50, crime victims assessment of $75, $350 in court costs, and a $200 fine, penal fine for a total of $675. And you have to make arrangements to pay that at the clerk's office. If you can't pay it in full, you can set up a payment plan with my staff at the circuit court. Because we are entering a judgment of sentence, you can file an application to appeal to the Court of Appeals. If you want a lawyer appointed for you, you'd have to ask me within 6 months. We're going to hand you a piece of paper about those appeal rights and ask you to initial one copy for us. And the other one is for you to fill out if you want to take an appeal. We'll get the judgment of sentence done today. And I imagine with credit, you should be released. The jail will calculate your out date. And then you're all set with us, other than paying that fine off. You won't be on probation. Okay. Good luck to you. Mr. Nightingale, I do have an amended information that has the operating second and the Knox County as a prior. Do you consent to its filing and waive its reading?
Do, Your Honor. Thank you.
Okay. All right. Thank you very much, Mr. Nightingale.
Thanks, Judge. Have a good day, and thanks for squeezing us in.
You too. All right. That'll conclude our docket this morning.
I'm gonna go ahead and call this one for today. Yeah, that's not good, Linda. When I get a chance, I'm gonna put the Riverside Fire, Cal Fire Riverside back on Broadcast-TV and listen to hear what's going on. But that's it for today, ladies and gentlemen. I appreciate everybody who comes to this channel and watches. I appreciate everybody. And if you're not subscribed to this channel and you like this content, please consider subscribing to this channel and helping this channel grow. And by all means, share these live streams out. Let people know that I'm here and what we're doing. So that's it for today, ladies and gentlemen. ciao, ciao, and ta-ta, and have a wonderful evening. I'll catch you on the next one.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your hour, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything